that Ajit Pawar faction was the real NCP political party when the rival factions emerged, the respondents cannot be held to be disqualified for grounds recorded in paragraph 76A and B. Even otherwise, irrespective of my conclusions about which faction was the real political party, for the reasons recorded herein below, the respondents cannot be held to be disqualified on the grounds recorded in paragraph 76. Irrespective of my conclusions on the real political party, in my considered opinion, none of the averments, contentions or pleadings raised by the petitioner, especially grounds C to H recorded in paragraph 76 herein above, fall within the ambit of paragraph 21A of the 10th schedule of the Constitution. It is necessary to understand the scope and object of the said provisions of the 10th schedule of the Constitution. The object underlying the said provision was to curb the evil of political defection motivated by various considerations which endanger the foundations of our democracy. What is to be noted is that 10th schedule is intended only for the purpose of prohibiting and punishing defections, and that too with the objective of preserving the foundations of democracy. I am pained to observe that in the present matter, when the facts, circumstances and evidence are viewed, the misuse of the provisions of 10th schedule by political parties becomes apparent. It appears that the initiation of the proceedings is not to prevent maverick and irresponsible defection or to call an errant member to book. It is to suppress dissent within the party and open a new direction in the political tussle for power. The attempt is to stretch the provisions of 10th schedule to suit private objectives of individuals or parties rather than prevent the harm that is caused to elective democracy itself. In the facts and circumstances brought before me, it is necessary to consider the cardinal question: does every act of a member of the legislature that may be described as defiance or dissent or behavior of group of members of the legislative party in the House that goes against some other group within their own party falls within the meaning of the term defection under paragraph 2 of the 10th schedule? As the Speaker and even as an elected representative, I witness the daily churning of politics as it plays out before me. I see members, their political leaders and their parties as if through a kaleidoscope, making and breaking into new forms, forging new alliances, undoing old relationships, striking out in unknown directions. This is in the very nature of politics, and as we see it unfolding before our eyes, it is the reality of politics today. Surely every such action cannot qualify as defection within the meaning of the 10th schedule. The constitutional bench in the case of Kyoto Holohan versus Zuchilu and others has somewhat touched upon these aspects. I have referred to Kyoto and how Kyoto has dealt with these issues. Then, would every act of defiance or dissent or behavior of groups of members that goes against some other group within their political party fall within the meaning of the term defection under paragraph 2 of the 10th schedule? The question, no doubt, is foundational, but by no means is it the only question that arises for consideration. The companion question that arises is equally fundamental. Is the 10th schedule a tool to control opposition within the political rank of the party? Assuming that rightly or wrongly, the behavior of the acts of the respondent in these groups of petitions of raising their voice against Shri Sharad Pawar and disobeying the diktats of Shri Sharad Pawar amounts to indiscipline, could such action amount to members having voluntarily giving up membership of the party, thereby attracting disqualification under the 10th schedule? The event that unfolded between 30th June 2022 and 2nd July 2022 were clearly in the nature of intra-party dissent within the Nationalist Congress party, and the members of the party stood divided between two leaders, i.e. Shri Sharad Pawar and Shri Ajit Pawar. But this conflict was clearly within the political party. Questioning the decision of Shri Sharad Pawar and going against his wishes cannot be said to be an act of defection or of leaving the party. It is a dissent expressed by the members of the NCP. At no point of time did any of the leaders, including the respondents, ever made any attempt that would amount to a statement or contention to leave the NCP political party. Members of the party expressing concerns against certain political behavior of other members of the party would not constitute defection. Under the 10th schedule, such collective dissent would remain to be a dissent within the political party. Even when it began to be raised publicly on the platform other than party forums, it may not be to the liking of this leader or that, but it would still remain to be a dissent and not desertion. A word about dissent. Intra-party dissent by individual members of a political party need to be distinguished from collective dissent of a group in the legislative party. It further needs to be established that if such collective dissent has occurred, it amounts to defection from the party. Here, an examination of the motive also becomes relevant. I need to decide whether collective dissent against the party leadership can be termed as honest dissent within the political party, permissible in a democratic institution such as the political party. Further, whatever be the nature of the dissent, can it be given the status and character of dissent within the legislative party, which alone is a dissent on which the Speaker is empowered to act under the 10th schedule. A useful reference may be made to the recent judgment of the Honorable Supreme Court in the case of Balchandra L. Jarkiholi and others versus B.S. Yediyurappa and others, reported in 2011 7 SCC 1. It is an interesting case which had come up before the Honorable Supreme Court from state of Karnataka and touches upon this aspect. The fact of the said case were 13 MLAs of BJP and 2 other independent MLAs wrote to the Honorable Governor indicating that as MLAs of BJP, they had become disillusioned with the functioning of the government headed by Chief Minister and also the leader of the legislature party who belonged to their own party. After stating their reasons, they added that they were withdrawing support to the BJP government headed by Mr. B.S. Yediyurappa, but they would support BJP government with any other leader from BJP in its place. On the basis of the said letters, Governor asked the BJP Chief Minister to seek vote of confidence in the Legislative Assembly and also intimated this to the Speaker. On the same day itself, the Chief Minister filed disqualification petitions against his own MLAs, accusing them of voluntarily giving up membership of the political party. Upon issuance of show cause notice, the MLAs filed a reply stating that they did not intend to withdraw support to BJP but had withdrawn support only from the government headed by Shri Yediyurappa and that they would support any BJP government headed by a clean and efficient person. They asserted that their conduct did not fall within the scope of paragraph 21A of the 10th schedule. The Speaker, however, disqualified the MLAs under paragraph 21A of the 10th schedule. The Speaker's decision was challenged before the divisional bench of Karnataka High Court. The division bench, comprising of Honorable Chief Justice and Justice N. Kumar, gave differing judgments. The Honorable Chief Justice rejected all the contentions of the MLAs and dismissed the writ petitions, while Justice N. Kumar, in his separate judgment, differed with the views of the Honorable Chief Justice in regards to interpretation of paragraph 21A of the 10th schedule and set aside the Speaker's order. The matter was then referred to, to a third judge, who in turn concurred with the judgment of the Honorable Chief Justice. Thus, by a majority, it was held that Speaker had rightly disqualified BJP MLAs. The order of the Speaker and the judgment of the High Court was challenged before the Honorable Supreme Court. In its judgment, the Honorable Supreme Court extensively referred to with approval the observations made by the dissenting judge of the Karnataka High Court, Justice N. Kumar. I am in complete agreement with this view and am bound by it. I reproduce the said paragraph which are relevant for the present purpose. Justice N. Kumar, who along with the Chief Justice heard writ petitions filed by the appellant herein, in his separate judgment, differed with the views expressed by the Chief Justice in regards to the interpretation of paragraph 2(1)(a) of the 10th schedule of the Constitution. The learned judge went on to further hold that when a member of a house expressed his no confidence in the leader of a legislative party, and if he happened to be the Chief Minister who is heading the Council of Ministers and had written to the Governor in that regard, such act by itself would not amount to an act of floor crossing. Similarly, if the Governor, after taking note of the expression of no confidence, was satisfied that the Chief Minister had lost majority support in the House, he could call upon the Chief Minister to prove his majority on the floor of the House. It was further observed that if the Chief Minister, on such request, failed to establish that he enjoyed the support of the majority of the members, the ministry would fall. But such an act of the member of the House would not constitute defection under 10th schedule. By such an act, the political party which had formed the government would not lose its right to form a government again. On the other hand, what is disturbed by such an act is the government of the political party with a particular leader in whom the members of the House belonging to the same political party have no confidence. But this would not mean that the member of the political party to which the Chief Minister belonged had given up his membership to the political party.